Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Welcome to the Mineral Rights Podcast. Thank you so much for joining us. My name is Matt Sands, and I'm here to help you make the most of your mineral rights and royalties. Justin Williams joins me again today to provide the individual mineral owner perspective, and today we're talking about surface use agreements from both the perspective of the surface owner as well as the operator. But before we get to today's show, I have a quick reminder. Please subscribe to the show on iTunes or wherever you get your podcasts, and please leave us an honest rating and review. It only takes a minute, and it will help us reach everyone that needs to hear this information. And to ask a question to be featured on an upcoming episode, you can leave a comment at mineralrightspodcast.com just below the show notes for this episode, or you can send an email to feedback@mineralrightspodcast.com. And without further ado, let's talk about surface use agreements.
Today we're talking about surface use agreements, which is kind of an interesting thing and a little bit different than the mineral estate. The definition of a surface use agreement is a contract between the surface owner and the lessee, usually the oil and gas company, to an oil and gas lease. This contract outlines the rights, duties, and obligations by both the landowner and operating, including things like the size of the surface disturbance that will be allowed when constructing well paths and roads, compensation for any property damage that might be done by the operator, and this agreement helps resolve an uncertainty for both parties. And this is something that a lot of times, if you own the surface and you've been using this as farming lands, you want to understand completely how they're going to be coming in and utilizing this and how it will affect you making money and utilizing your land. Some states require that before a well can be drilled, that the surface use agreement is in place. Most of the states provide oil and gas operators with the access to the surface estate overlying any reservoir to be drilled. The mineral estate sometimes is called the dominant estate, and that means that the mineral estate is entitled to be able to access the surface estate so that they can develop those hydrocarbons and be able to get it produced. With an advent of horizontal drilling, minerals below the surface well pad may not actually get developed, since producing zones may be under other tracks. And this has become something interesting because with horizontal, that doesn't necessarily mean that the well pad's going to be right there above where they're producing the hydrocarbons. Some states have passed legislation to help navigate this, which we'll touch on and talk about a little bit later. Something that I think a lot of people don't realize with surface use agreements is kind of how it looks when the oil company is actually going to be coming in and what all is the oil company going to do to their land. And Matt, can you kind of give them a time lapse, a big picture of what the surface owner can expect when the oil company comes in and starts getting ready to gear up to produce?
Sure, Justin. Yeah, the oil company will come in, and even before they physically show up on site, you should expect that they'll notify you in advance of what their plan of operations is going to look like so that you can provide input that you all will be on the same page with respect to how you're using the land and what they're going to do, and that you guys won't conflict with each other. So beforehand, you should expect to get notified both with respect to the plan of operations as well as the timing for when they're planning on drilling the well. But if you were looking at this, if you'd set your GoPro in time lapse mode there at the well site and let it run for the duration of the drilling operations, what you would expect to see is if there's not already an existing access road to where they're proposing to put the well pad, they're going to first build the road. And one of the things that a surface use agreement might cover are things like how the road will be built, what the materials that are allowed, all the details you would need to know when going to build a road so that you have input on that if that's important to you. So once the road is built, you'll get the actual grading of the well pad site to make it level and flat for a rig to come on. The size of the well pad will vary depending on the location and how many wells they're going to drill, but typically will be at least several acres. Usually it's larger than that during the drilling operations, and then they'll do some interim reclamation to bring it down to the final size during the production phase. So once that well pad is built, they'll come in and often install a surface conductor, which is a piece of pipe that sort of extends from the ground level down, where the wellhead will go, and where they're going to drill the well or wells. And so they'll come in and do that. And then they might bring in a top hole rig, which is a smaller rig to drill the vertical section of the well. Typically, they would do this, and because it's cheaper to operate, and they may have some efficiencies if they're able to use a smaller rig to come in while the other rig is finishing up drilling any wells on other well pads. So once that's done, then they'll bring in the main drilling rig and they'll drill the well. And what you would see there is over a period of, week to 2 weeks or even longer, if it's extremely complex or deep or long well, they'll come in and drill. So that you'll see certain things on the site. You'll have mud equipment that they use while drilling to help remove any cuttings that are drilled from the actual formations as the bit goes down. You'll have other companies come on site. Maybe there's logging companies that'll come. So other subcontractors and service companies will show up on site. You'll see tanks, see staging of equipment and materials. There'll be drilling trailers. So there'll be like an office trailer for the company man and for any other engineers or other folks that come on site that they can have a place to work while drilling is going on. And then once the well is drilled, or wells, if there's going to be multiple wells drilled, once that's all done, that rig will move off, and then you'll get a completions crew come on site. So that's where you hear about fracking and hydraulically fracturing. So you'll see kind of a rat's nest of piping connecting to each wellhead where they can run a high pressure water and then the proppant and any other additives or chemicals they need during the fracking operations. And so you'll see tanks there for the water. You'll see pumps and other equipment, and then lots of pipe. And once that's done, they may bring another small rig on site to drill out any plugs that were installed between the different stages that they did while fracking. And then you'll see some potentially temporary flowback equipment. They'll run any produced water to dewater the well, and then they'll bring in the surface kit that they're going to install. So that's the tanks, the separators, and the final production equipment that are going to help process the oil and gas that come out of the well, so they can connect it to a pipeline. And that actually is another thing that would occur beforehand. Typically, is if there's any flow lines or pipelines that need to be installed. Usually, that's done before the rig gets on site, so they can just connect the well up and start flowing once things get completed. So, um, and then once all that is done, and in between there, you'll see various things that we'll talk about more specifically as it relates to claiming some of the land and specifics related to that you can request in a surface use agreement. So, for the duration of the well, that surface kit or surface equipment will sit there on the well pad to allow them to produce oil and gas from the well. The thing that you would need to think about is, how do you negotiate this surface use agreement? And I'm going to refer to this sometimes as an SUA, so just an abbreviation that's commonly used in the industry. First thing is that, like an oil and gas lease, most operators just want to strike a mutually beneficial deal that is going to allow them to develop the minerals under your land in an economic fashion. That said, obviously you need to protect your interests if you're the surface owner, and you got to be reasonable too. So the thing that you got to think about is, are you making reasonable requests to the operator that is something they could actually follow through on? So obviously, this is an important negotiation if you are faced with a split estate where you don't own the mineral rights below your land, and an operator is coming on site or proposing to come and build a well pad and drill wells, because this is your one time to have an impact on the financial consequences for these activities, both positive and obviously trying to prevent any negative outcomes. And so it's equally as important when you are negotiating this agreement that you do your research and you have a competent advisor to help you get the best outcome. And so what that would look like is hiring an attorney that's qualified in oil and gas law in your jurisdiction, and they can help you review any agreements and make sure the language is included to protect your rights. So, ideal situation would be the operator's willing to sit down at the table and listen to your concerns and for you to be able to trust them. Hopefully, they're going to come in and try to build trust and to demonstrate that they're willing to listen. And then you got to show that on the other side of that. So it's got to be a two-way street. So this is one situation, possibly even more so than an oil and gas lease, where you really don't want to go it alone. The reason being is that there is not a standard SUA form that's out there. Like we said, with oil and gas leases, you have the producer's 88 form, which is, you could argue, is somewhat standardized, even though there are variations and language is obviously not standard between one lease to another. With SUAs, it's even worse. So you could have an SUA that'll vary from operator to operator or from region or basin to basin. And you can't rely on some sort of standard form or some standard language that's been vetted by, the state legislature or something like that that's going to protect you. So know that you need help when you negotiate this document. The other aspect of this is that if you do own the minerals under your land, either in part or in all of them, a good place to negotiate the surface use provisions is in the actual oil and gas lease. So oftentimes in the lease, you take a look at it, it'll have things on there about access to drill a well and use of water and et cetera. And so you can insert language in that agreement to protect you with respect to those things. And then the final thing is, if you are the surface owner in a split estate scenario and you lease the surface to a tenant, it is important that that tenant actually has a seat at the table to make sure that their use of that land. So, for example, if you have a farmer that is leasing your land and he gets his income from harvesting crops, then he needs to be involved to make sure that they're fairly compensated for any potential financial loss due to maybe loss of some of the surface leasehold for agricultural purposes. So if you're building that well pad that's going to sit there for the next 30 years, that's potentially 4 acres or whatever the size of that well pad is, that is not going to be accessible to plant corn or whatever is being grown. So that would need to be something that's considered in the whole discussion. Justin, you want to talk a little bit about some of the statutes that have been passed that help protect surface owners?
Absolutely. And states such as Colorado, Wyoming, North Dakota, and Texas all have passed some legislation that make sure that the oil and gas companies have certain steps to take when there is a split estate. Um, these protections require notifying the surface owners of things like the start date of drilling, a copy of the plans of operations, and contact information for the operator so that they can reach out to them and find out more. They also require compensation for surface disturbances like pipeline installation. If the operator and the surface owner can't reach an agreement on damages, some state grants the operator the right to proceed with the development with damages to be determined through arbitration or litigation after the fact. And that definitely wouldn't be ideal for anybody. You would like to reach an agreement up front that to be sure that they are going to do what you know and they're not going to do anything that really would impact you. Clauses that they do have on just specific clauses that are something to note. In no particular order, there are things to consider when negotiating a surface use agreement. Remember that pretty much everything is on the table for negotiation as it relates to water usage, land usage, and leasing your minerals. Some of the things that you want to be sure of and that will be there. The legal description, like with an oil and gas lease, it's important that the affected land is adequately described. Otherwise, you will risk the entire agreement being considered void due to uncertainty. Matt has a blog post on legal land descriptions with a link in the show notes, and that'd be something to take a look at, because if you're not used to seeing those, it definitely can be a little confusing for you. Term, again, like a lease, it's important that the duration of the agreement is outlined. No standard language, but you could consider setting a duration to the life of the lease or drilling unit, plus additional time afterwards to allow for the removal of any equipment and to allow for final reclamation to take place. Compensation language may be included that provides any compensation outlined in the SUA and is considered exclusive. In other words, you can't later make a claim for additional compensation. This is something you want to be sure that you are aware of and you think of everything that's coming in the SUA. Liquidated damages. It's a set payment based on the size of the disturbance. For example, the pipeline, right of way, square footage for wells pads, roads that they're going to put in that weren't existing before, and other things that might be sitting on your land and taking up space. Something else that, if you're in a situation of a split estate, an overriding royalty interest, which is a piece of the working interest from the oil and gas company, is something that you can try to negotiate with the oil and gas production. And then this would give you a piece and a common goal, so that when they are producing the oil and gas, you're receiving a percentage of what they are selling on that oil and gas and keeping you tied into the monthly revenue. Everything in between, including the bonus, as far as the compensation for surface damages, a royalty, a bonus plus an annual rental payment, water usage, anything else is negotiable and something to be covered. You want to be sure that anything that may impact you is going to be outlined in that surface usage agreement. And Matt, you want to talk a little bit about reclamation, which is something they want to be sure that they leave the land in the condition that it was and they bring it back to usable for you.
Exactly. Yeah. So there's really two types of reclamation that are most common. You have interim reclamation, and this is the process of restoring any disturbed land after the drilling phase takes place. And so this is where you'd see the well pad footprint get reduced down to the final size that is required for the production phase. And what you would see here is, things like replacing any topsoil that was removed, weed control, and then reseeding any pre-existing vegetation. So what they try to do is match whatever was there before to the extent possible. If that's including crops and so forth, that might be something you'd work and want to make sure that is included in there exactly what gets replanted and where. And then once you have the final drop of oil or any final cubic feet of gas gets produced, and they go to plug and abandon the wells and remove everything, then there's that final reclamation step, and that's where any contamination that might have been caused that would be need to be removed and cleaned up. Be things like removing and regrading any access roads, purging and capping any flow lines that are left below ground, and replacing any topsoil, and again back to the providing vegetative cover over any disturbed lands. And so this is where you'd like to see that look like a picture of what it looked like before after they're done. And that's definitely something that is a concern to responsible oil and gas operators, and so they're willing to work with you on that. And again, if you have any specific usage for that land that you plan on using that for. So, for example, if that's going to be restored back to croplands, you'd probably want to make sure that anything that could be hit by a plow is obviously removed or at least cut down well below that depth requirement. And so that all would need to be outlined in that SUA. Finally, a couple other provisions that you'd need to think about. Things like location of roads, any production facilities, location of any temporary housing or office trailers or other temporary equipment they're going to bring in during drilling operations. And then if you have the water rights, I know which is a big deal here in the West, you'd obviously want to make sure that there's specific language there that outlines how any groundwater or surface water is going to be used and what are the water testing requirements. And so if they're going to put a water well and you're going to allow them to get water from your land, then you'd have to have all that information in the SUA to make sure your rights are protected there. At the end of the day, you just got to make sure the terms of the SUA are not going to negatively impact your ability to use your land to the extent possible. Obviously, the surface footprint of that well pad is going to be something that's going to impact you, but financially, I should say that you're not going to be negatively impacted there, that you'd have adequate compensation for that well pad existing and maybe you not being able to use that area during the duration of production. In general, you want to make sure that that SUA has an outline of all of the permitted and prohibited activities by all parties that are involved to the agreement. And that could be, again, obviously the operator, if you're the surface owner, and then if you have a surface tenant, that they're included as well. And then, no matter what side you are on, if you're a landman negotiating this, you'd want to make sure any agreements are in writing to avoid any later conflicts if you get into a situation of dealing with maybe an unreasonable landowner. Or on the flip side of that, if you're the landowner, you got to make sure that stuff is in writing, so that you're protected, so that you don't have any verbal agreements that maybe that person that made that verbal agreement goes on and leaves the company and goes to work somewhere else, and then they aren't going to uphold that. So if it's not in writing, don't expect it to happen, basically. This is just really a scratching the surface of surface use agreements. Again, we just wanted to provide an overview to help shed some light on this and why it's an important thing to consider in a split estate situation. And again, thinking about that dominant estate that Justin mentioned earlier, that's no longer something operators can hang their hats on due to horizontal drilling. So in the past, where in some jurisdictions, you could come in and the mineral estate is the dominant estate, you could come in and drill, and you have to be reasonable in your approach to the surface owner to help provide certain notifications and or make a reasonable attempt at trying to negotiate with them. But because oftentimes where the surface location is for that well, you're not actually producing the minerals directly below that well pad. You're actually drilling down and into another tract of land where the actual completed zones are, and that you're producing minerals that are maybe in an adjacent tract of land. And so it's ever more important that the SUA covers all bases when faced with that situation. And like any negotiation, you want to have your goals in mind. So you want to write down what are the things that you want, what's the desired outcome from the negotiation before you sit down at the table, and so that you can end up with an agreement that you can live with. And we'll have a legal expert dive deeper on a future episode. But again, in the meantime, we hope this helps shed some light on this subject. And as always, please go to mineralrightspodcast.com to find the show notes. We'll have some links to some good articles we found on this topic, as well as a link to the legal description episode that Justin mentioned. And if you have any feedback for us or request for a topic for a future episode, shoot us an email at feedback@mineralrightspodcast.com. And if you found this to be helpful, we always appreciate a rating and review on iTunes or wherever you get your podcasts. We read each one, and we greatly appreciate comments and the reviews we've gotten so far. And you can get a shout out on a future episode if you leave us a review. And again, this is really important to us because it helps us reach other mineral owners who need this info as well. So please take a minute to do so if you haven't already. And thanks, Justin.
Thank you, Matt. Talk to you soon.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.